Mr. Clement, the government says that its starting point is that whether or not this is you've established that the respondent is salaried, and he argues that he does not receive his compensation on a salary basis. I guess the government's argument is that once you make that determination, you're on an entirely different track from being on a wage basis. And although your case, in this case, respondent makes quite a bit of money, you're suggesting that we can bypass determining whether or not he is on a salary basis. So one, is being that determination of being on a salary basis a sine qua non of bypassing all of these regs that you're talking about? If not, how do we establish that you're highly paid? Why don't we just consider your highly paid respondent here to simply be a wage earner, but a highly paid wage earner?
So, Justice Thomas, the way I'd respond to that is that Section 601 does not require a worker to be a salaried worker or to get any particular sort of like be in general or mostly paid on a salary basis. It's very specific. It says the total annual compensation has to include at least $455 a week on a fee or salary basis. So that requires you to look at Section 602, but then to figure out how much you get on a salary basis. Section 602 doesn't, again, tell you whether you're mostly a salaried worker or a salaried worker in the abstract. It's very specific, and the test is really what is the amount that you receive in any week in which you work at least 1 minute. And for this worker, that was $963 or more, and that $963 was a guarantee. So if you work even a minute in a week, you're going to get $963. That's a predetermined amount. That satisfies what the only requirement vis-a-vis a salary basis in Section 601, which is that your total annual compensation include at least $455 on a fee or salary basis. So